Good morning. Yet another case wherein whether suit for declaration to declare the marriage is a null and void is maintainable before the Family Court Act. Another aspect was this the degree passed by the Family Court was challenged in appeal before the division bench of Patna High Court, wherein the claim was they refer section 34 of the Specific Relief Act, which says that declaration may not be granted where the plaintiff being able to seek further relief than a mere declaration of title omitted to do so. So wherever a question of declaration was sought, you can very well defend that the consequence relief was not sought for. It's all right. Then question arises, this is AR 2026, Patna 20, page 20. AR 2026, Patna 20, Anjani Kumar alias Pappu Kumar versus Mamta Bharti and another. So, when it was challenged, the issues were first, whether the matrimonial case as framed is maintainable. For declaration, seeking the marriage between the first and second respondent is null and void. Then, second issue that whether the marriage of applicant respondent solemnized with opposite party number 1, appellant on so-and-so at village Lahu district is maintainable. The second is as per decide the Family Court has held marriage was solemnized between applicant respondent number 1 with opposite party number 1, appellant on 29/6/2000 at village. Third issue is whether opposition party 1 appellant had entered into another marriage after marriage with Mamta Bharti, which is in gross violation of section 5(1) of Hindu Marriage Act. That was also decided in favor of the opposite party. Applicant, respondent number 1. Whether applicant respondent is entitled to any other relief or not. This I will decide in favor of applicant, respondent number 1, held that court that applicant respondent is entitled for the relief available under section 11 of the Hindu Marriage Act. So actually the division bench very interestingly decided the issue. The ratio was that in civil proceedings, standard of proof is preponderance of probability. Family Court reached on finding on basis of consideration of different exhibits and oral evidences, found preponderance of probability in favor of husband. As matrimonial suit was decided based on preponderance of probability, minor contradictions in oral evidence shall not help wife for challenging grant of degree in favor of husband. Then question arises, suit for declaration of marriage as null and void maintainability because subsequent additional prayer was not sought. 7.1 explanation clearly states suit for proceedings for declaration to validity of marriage or to matrimonial status of person is maintainable before principal judge of family courts. Section 20 of the said Family Court Act further provides that provisions of Act shall have effect notwithstanding anything therein contained in any other law for time being in force or any instrument having effect by virtue of any law other than this Act. Matrimonial suit seeking declaration of marriage is null and void is maintainable. So they have decided this by reading section 11 and 5 of the Hindu Marriage Act. All these things has been decided and a very short paragraph. Say then the section 34 of Specific Relief Act or Specific Relief principle shall not be applicable upon the suits filed under Family Courts Act due to Section 20 of the Family Code 1984. Therefore, the Specific Relief Act 1960 has come into existence in 1963 and the Family Court Act 1985 has come into existence in the year 1984, and the provisions of Family Court Act have been prevailed by Section 20 in the year 1984 or any other law. This is what they have interpreted. Kindly go through this judgment and develop your mind so that you can do best in before the high courts, and if you are preparing for examination, this will definitely help you. Best wishes.